Thank you, Mr. President. My colleagues, this Thursday is New York's 246th birthday. As many of you know, for the last few years, I've stood on this floor to commemorate April 20th as New York Constitution Day, the anniversary of the ratification of New York's first Constitution after we joined the other colonies in declaring independence from England in 1777. This year, I want to spend my time talking a little bit about that first Constitution and something that I think is both interesting and actually somewhat relevant to an issue that this body has spent quite a bit of time on this year, the judiciary, and more specifically, the Court of Appeals. But at the outset, I want to acknowledge and thank the law librarian in the Legislative Law Library, Jeff Buckley, for his help in researching this year's topic with me. The Court of Appeals was not created until the Constitutional Convention of 1846. So I actually want to talk about the predecessor to the Court of Appeals, which was the Court for the Trial of Impeachment and the Correction of Errors. This court was to be the Court of Final Appeals in New York, a chance to literally review the errors of the lower courts below and to issue final judgments. It was a holdover from the colonial judicial system, which itself was an imitation of the English House of Lords, which up until 2009 was the final arbiter of judicial appeals in the United Kingdom. The Court for the Trial of Impeachment and the Correction of Errors, which is quite a mouthful of a name if you ask me, was composed of the Lieutenant Governor, the Chancellor of the Court of Chancery, who at that time was the highest judicial officer in the state, the judges of the Supreme Court, and the 32 members of the New York State Senate. The Constitution said that when cases came up on appeal, if it was a case that was previously decided by the Supreme Court judges, those judges could not vote on the appeal itself, but only explain their rationale to the other members of the Court of Errors for their contemplation and consideration. Similarly, the same held for the Chancellor on any cases on appeal from his prior decisions. And the thinking at that time was that an assemblage of a large, nearly 40-person body of esteemed, preeminent government officials could hear these appeals and that their collective wisdom would lead to the correct result. But in practice, actually, there was an expectation that the non-judicial members of the Court of Errors, namely the senators, would be deferential to the judicial wisdom of the other judges and would simply rubber stamp their decisions. I'm going to come back to that point in a minute, but first, I want to just pause for a second to reflect on this idea that was enshrined in our very first Constitution, that members of the legislature would simultaneously serve as members of the judiciary. Just think about that. The people who wrote the laws were also the same people who would have the final say as to whether those laws were or were not valid. That really strikes at our understanding of the separation of powers, which is a defining feature of the American system of government and one of the strokes of genius that shaped our founding fathers in Philadelphia a decade later. But on the other hand, maybe we shouldn't be so surprised because at that time, again, we're talking about the 1770s, 1780s, courts primarily decided cases about common law and equity. It wasn't until 1803 in Marbury versus Madison that the idea of judicial review of executive and legislative actions was even established as a judicial power. But nevertheless, for some 40-odd years, from 1803 until 1846, the members of the Senate would write laws and then hear judicial cases on appeal, often about the validity and constitutionality of the very laws they themselves wrote. I think that's fascinating. Now, separation of powers aside, the problems with the Court of Errors were many. For starters, there was no consistency in how the court heard cases. On any given case, there'd be anywhere from 20 to 25 members of the court who would vote. And when it was time to issue a decision, the members of the court never actually consulted each other. Each Court of Errors judge would reach their own decision based on their own rationale, and that was it. So if the 20 judges heard a case, they'd sit around a table and then vote to affirm or reverse, and that was the end of it. No deliberations, no discussions, no unified written decisions, nothing. Each judge was free to write and publish their own opinions, but there was no way to know if the rationale that persuaded one judge applied to any other judge, let alone a majority. You know, we spent a lot of time in the Judiciary Committee yesterday and today talking about stare decisis and the value of precedent. But under the Court of Errors, which existed in this state for 70 years, there was no way to know what each ruling meant for creating precedent and how to decide future cases. In fact, in a great deal of cases, the Court of Errors, or more accurately, the lay members of the court, the senators, would vote to reverse lower courts, often for reasons that were specious, frivolous, or even flat-out contrary to principles of settled law. In one case, Smith and Hoe v. Acker, Senator Hopkins, in voting to reverse a lower court, openly admitted that his vote would directly conflict with the whole course of the decisions of the Supreme Court, but that he knew better because his mind was not embarrassed by the past decisions that should have dictated affirming the lower court's ruling. This led a judge on the Supreme Court, Justice Bronson, therefore also a member of the Court of Errors, to go so far as to say that the decisions of the Court of Errors, although final as between the parties, are so far from being conclusive by way of authority that they are entitled to much less weight than the judgments that those courts which consider themselves bound by legal adjudications. And in this case, the judgment is entitled to no weight at all. In other cases, it was not uncommon for senators to rule in favor of litigants who were also their own constituents, or even worse, their own political allies. In fact, some savvy litigants would go see their senator as if during constituent open hours and really go talk about the case that they had pending before the Court of Errors. By the 1830s and 1840s, the problem with the court was well known. And as one commentator writing in 1843 charitably described it, he said, "The Court of Errors is frequently constituted of the Senate alone, and yet in the absence of every judicial officer, the gravest matters are often discussed, and questions of law which have tasked the wisdom of the ages are reviewed and settled by men who, if they have any acquaintance with the high matters placed under their cognizance, must have it only instinctively." As we know, in 1846, New York held a constitutional convention, and the records of that convention tell us that the necessity of revising and reorganizing the judiciary system was one of the principal causes for calling the convention. The records continue. Dissatisfaction had long existed with regard to the construction of the present court for the correction of errors. It was believed by many to be too numerous for securing the strict attention of all its members to the elaborate arguments frequently made before it in complicated and difficult cases. Its connection with the legislative branch of government was justly regarded by many as a fault in its organization, and particularly so with respect to the decision of all causes in which the constitutionality of an act of the legislature was drawn in question. And so, at the conclusion of that convention, a new constitution was proposed, the third in our state's history. And Article 6, Section 2 of that constitution provided that there shall be a court of appeals composed of 8 judges, of whom 4 shall be elected by the electors of the state for 8 years, and 4 selected from the class of justices of the Supreme Court having the shortest time to serve. So here we are. The Court of Errors lasted for 70 years, and in the years since then, the Court of Appeals has been our highest court in this state. By now, most, if not all, of the Court of Errors decisions have been superseded by relevant and more modern Court of Appeals decisions, and they're rarely cited. And at times in our state's history, the Court of Appeals has been considered the preeminent state court in this country. So as we consider the nomination that's before us today and potential nominations that will come before this body in the future for members of that court, and as there is a renewed focus not just on our state judiciary, but on the role of state courts generally, let's remember not just this history that I shared today, but the importance of our state's entire constitutional history. We should study it. We should know it. And yes, we should even talk about it like I am here today. So with that, Mr. President, thank you for your indulgence for letting me take some time. I'll close out by saying to my colleagues, Happy Constitution Day, happy birthday, New York. Thank you.